Okay, we will move on with the cases on the agenda, and before I get started, I'll read this opening statement to the applicant. If you're not satisfied with the decision made by the Stormwater Management Committee, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the committee's decision. You're advised to seek the independent advice of legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements have been satisfied. And this is a combination of cases, unless you want them heard separately. This is case number 2016-00036. This is 2655 Miami Avenue, APN 052-090-15100. 2016-00037. This is 2659 Miami Avenue, APN 052-090-15300. And case number 2016-00038. It's number 2661 Miami Avenue, and the APN is 052-090-15400. And the inspector is Kimberly Hayes. And before we get started, I will be stating that this is a request for rehearing. And let me go ahead and read from Appendix F, that portion that pertains to the rehearings. And I'll start at this section. This is on page 8 of Appendix F. If the motion or written request to reconsider receives 3 affirmative votes, the committee shall hold a rehearing, subject to such conditions as the committee may by resolution in each case stipulate. No request other than by a committee member to grant a rehearing will be entertained unless new evidence is submitted which could not reasonably be presented at the previous hearing. If the request for a rehearing is granted, the case shall be put on the calendar for a rehearing. In all cases, the request for a rehearing shall be in writing, reciting the reasons for the request, and shall be duly verified and accompanied by the necessary data and diagrams. The person requesting the rehearing shall be notified to appear before the committee on a date to be set by the committee. Such notification shall be by the secretary. The applicant's request. All 3 cases were previously deferred on December 1st, 2016. On January 5th, 2017, a motion failed to approve the variance request. The appellant has submitted a written request for rehearing for each case, stating that, quote, that they, quote, believe the committee's decisions on January 5th, 2017 were made based on incomplete and inaccurate information, and has provided exhibits which the request states is, quote, new evidence which could not reasonably be presented at the previous hearing. The original variance request for each case is to allow the following. 1, disturbance of the 50-foot Zone 1 of the 75-foot floodway buffer of the Cumberland River for construction of a single-family residence, including a porch, steps, and deck on the ends of the house. 2, disturbance of the floodway of the Cumberland River to construct cantilevered portions of the house over the floodway, maintaining minimum low chord of the structure approximately 6 feet above the 100-year flood elevation. The BFE equal 421.1 feet. The cantilevered portions will include 2 balconies and 1 living space area. 3, modified buffer signage with alternate wording as approved and placement as shown on the record plan, each property line at existing tree line. And 4, continuous mowing of the buffer to the edge of the existing tree line as shown on the record plan. The appellant is Precision Homes Incorporated, Mr. Gil Smith, being represented by Mr. Walter Davidson and also Mr. Sean Henry. Comments. Stormwater staff. Previous stormwater staff comments from January 5th, 2017 are as follows. 1, this area of Miami Avenue was substantially inundated during the May 2010 flood. 2, post-May 2010 flood, Metro purchased 11 properties adjacent to and within this same area, 1/3 mile, including an unfinished single-family residence previously owned by Mr. Smith, parcel 152, and this was 2657 Miami Avenue. 3, the buffer regulations became effective September 1999. Mr. Smith purchased the lots on March 19, 2004. 4, stormwater staff has evaluated the purchase or swap of Mr. Smith's property and based on the asking price, $98,000 per vacant lot and $269,000 per lot developed, it has been determined that there is no opportunity to purchase or swap the lots. The pre-2010 flood property assessor value was $70,200 per lot, and the current property assessor value is $1,500 per lot. The current comment from staff. The appellant has provided a submittal for a request for a rehearing. However, staff does not believe any, quote, new evidence has been submitted which could not reasonably be presented at the previous hearing, unquote. Per section F1.1.6 of the Stormwater Management Manual. At the meeting, staff will be available to respond to the appellant's statement regarding, quote, incomplete and inaccurate information, unquote, and to the evidence submitted. Codes had no comment provided. Planning's previous comment on January 5th, 2017 will defer to Stormwater staff. The current comment is planning will not have further comments for these cases. The previous comments from Stormwater provide an effective premise for not granting a variance for any of the lots along Miami Avenue. Greenways, Cindy Harrison, the previous revised Greenways comment from January 5th, 2017. Shane Dennison and I visited the 3 residential sites on Miami Avenue on November 3rd, 2016, and met with November 30th, 2016, and met with the engineer and developer. We agreed to not object to their variance request on the condition that they grant a Greenways conservation easement and show it on their drawings, install permanent signs that indicate that a greenway will be constructed in the future, and that they will install a crusher-run trail at the time the units are constructed, which Metro will later pave to meet our greenway standards for design. The original comment, the Greenways Division is opposed to the granting of a variance permitting disturbance of the 75-foot buffer. It conflicts with the conservation mission of the Greenway system to protect the land along water corridors. The Greenways Division also requests a Greenway conservation easement if this property is developed. In their current comment, Greenway's comments remained unchanged from the revised comments we presented at the last meeting, and that would have been January 5th, 2017. I also have some comments from the council person and some other citizens. Do you want me to hold those, or?
I'd just read them in.
Okay. This is from Councilman Jeff Syracuse. Paula, I cannot attend this meeting, but please record my alignment with neighbors and do not support this rehearing and variance. And that's Council District 15. This is from Dorothea Hartley. She addressed this to Tom Palco. Dear Tom, I am opposed to these variances on Miami Avenue. Why do they keep kicking us while we are down? I am so sick and tired of my flood bills to the tune of $200,000. I had flood insurance too. I own 6 properties on Miami Avenue, and that flood devastated my life and finances. I am almost retirement age, and this was my retirement plan. Now I am trying like hell to pay my debts. Unlike our current president, I don't believe in bankruptcy. Then the wonderful clan of Metro takes my value away on my property at 2667 Miami Avenue that I paid $50,000 for, and then tells me I cannot sell it as it has no value. They value it at $1,500. Thanks a lot, Nashville. Now I hear they are changing their minds on all this. Does anyone know what they are doing out there? Does anyone care about the people, or is it the almighty buck that counts nowadays? Thanks for listening. And this is from Michelle Bowen Capps and Jimmy Capps of 2672 Miami Avenue. Hi, Tom. We own a house at 2672 Miami Avenue. We are concerned about the variance request on the riverside of Miami. We had understood that there wouldn't be any new homes built on the riverside because of the floodplain. We are also concerned about the possibility of too many weekly rentals on this quiet residential street. We have plans to move into our house permanently and worry about strangers coming in and out of the neighborhood on a nightly/weekly rental. Thanks for your consideration of the uniqueness of this neighborhood when making decisions affecting our wonderful Miami Avenue. And this is from the Pennington Bend Neighbors Association, Richard Lawler, President, at 2313 Pennington Bend Road. Dear Mr. Palco, since our situation on Pennington Bend is similar to that on Miami, I would like to state my opposition to any relaxation of the requirements for building next to the floodway. Should one developer be granted an exemption, then, as I'm sure you know, the following developers will want similar exemptions. Sincerely, Richard Lawler. This is from Carol Grace Anderson, M.A. she gives a P.O. Box 148258 here in Nashville. I'm a property owner on Pennington Bend on the riverfront. I vote for the variances that are requested. I've been a taxpayer on our property for 25 years, and I feel that we should be granted variances if the buildings are built 4 or 5 feet above flood stage. I see no valid reason to refuse those variances. Thanks for listening. Have a great weekend. This is from Kim Sorensen, 2627 Miami Avenue. Dear Mr. Palco, I have been notified that Gil Smith is requesting a rehearing regarding his wanting to build 3 houses on the riverside of Miami Avenue. This is in reference to case number, and then she cites the 3 case numbers, 2016-00036, 37, and 38. After the flood in 2010, the Miami and Pennington Bend neighbors were told that FEMA and Metro would no longer allow more building on the riverside. They said it was permanent. I'm hoping permanent doesn't really mean 7 years. The riverside properties were devalued and the property taxes were greatly reduced because they were no longer developable. At the time of the flood, Mr. Smith was in the progress of building a house on a 4th property that is next to these properties. The house flooded and he took the buyout. He got his full asking price even though the house was not completed, and now he wants to build 3 more next to that lot. I want to express my opposition to any more construction on the river, especially by Mr. Gill. I've lived across the street from 2 of Mr. Gill's other projects and have had to put up with heavy equipment in my driveway, fires burning all night with no supervision, trash piles that don't get cleaned up, repeated use of a backhoe slamming trash into a trash bin so hard that my entire house shook and I thought it would damage my foundation, and I think it did, and storing a backhoe in the neighborhood for 10 years. The construction of these houses took 2 years and sat uncompleted for a very long time until he finally finished them. I have heard him say that he was going to build on the river lots and would keep fighting it until allowed to do so. I asked him that Metro remain firm on their decision to not allow any more construction on the river. This is from Phil Claiborne. As the former councilman of District 15 during the 2010 flood event, I am very familiar with the Pennington Bend and Miami properties along the river. Based on that familiarity, I would suggest to you that almost all of the lots in question are either in the floodway, the floodplain, or the buffer. Any attempt to construct a home with the required elevated height would be the structure completely out of character with existing homes, riverside homes that survived the flood and did not take the buyout. The city has spent millions of dollars since the 2010 flood to buy homes that were flooded along the river, and since that time, these vacant lots have created something of a park-like riverscape that greatly increases the aesthetic look of the area. It would be a travesty to allow construction in a clear zone again after all that has taken place to get the riverbank to the state it is currently in. I would urge you to deny the request to build on these sites. Dear Mr. Palco, and this is, from Pam Miller, President, the River Glen Homeowners Association. I'm writing to express my opposition to the variance request, and she cites case number 2016-0036 for the following addresses on Miami Avenue, 2655, 59, and 61. A few weeks ago, the HOA Board of River Glen met with Trevor Hunt, the NRCS District Conservationist for Davidson County, to discuss erosion issues within our subdivision. During the course of that meeting, he mentioned that there were several erosion issues on Miami Avenue that would have to be addressed in the future. Further, I was surprised to hear that Mr. Hunt considered the erosion issues on Miami more critical than those in our subdivision, which we feel are substantial and extremely costly to repair. Given the erosion problem as well as the history of flooding for this area, it makes no sense to allow a variance so that homes can be built at these addresses on Miami Avenue. It is my fear that the builder will saddle an unsuspecting buyer with a future erosion burden and be long gone before the truth is revealed. The average person holds a large portion of their wealth in their home. I believe the city has an obligation to protect buyers from builders that care only for making a buck and not with whether the land the house is built upon is stable, sturdy, and free from known issues that will result in costly future work and loss of equity. And those are all the comments, and at this time I'll turn it over to the applicant or his representative.
Thank you, Ms. Key. Mr. Chairman, members of the committee, my name is Sean Henry. I'm a land use lawyer at 315 Dedrick Street with the law firm of Tunica & White, representing Gil Smith, the property owner. He's sitting to my right, and Walter Davidson, engineer, sitting to my left. We appreciate your consideration here today. We have filed this request for rehearing pursuant to your guidelines and your rules for doing so. Thank you for reading the letters. We were not aware that there were any letters submitted in support or in opposition. Importantly, these 3 lots on Miami Avenue are not within the floodplain. What we're talking about here is the buffer yard, and I think as part of your consideration back on January 5, based on my read of the minutes from January 5, the discussion and information that got exchanged got well beyond and well outside the scope of what the purpose of the buffer yard is intended to do and why we have a buffer yard. So this is a buffer yard encroachment, and it's rather minuscule. And again, in the minutes, I didn't see any reference to just how little of an encroachment we're talking about here, and I don't think the committee fully grasped that. So, for example, the information that you have in front of you now, the roof coverage that we're talking about here is less than 400 square feet. We're talking about an impervious surface from a roof coverage standpoint of something that's smaller than a garage. And regarding the lot coverage, so factoring in the foundation of one home and the driveway serving that home, we're under 800 square feet. So the roof alone is less than 5% of the lot area, and the driveway factored in with the foundation is less than 10% of the lot area. Again, negligible in the scope of considerations and information presented to you back on January 5 relative to flooding, historical flooding events, et cetera. And so Mr. Davidson has filed with you as exhibits, a series of exhibits that go to the discussion points from January 5 that you did not have in front of you. There was testimony from staff regarding substantial flooding events, and yet there was no data submitted to you in support of those staff comments. And so what we have now in front of you are several exhibits, the NOAA data sheet on the Cumberland River, the FEMA flood data and flood profiles, that's Exhibit 3. Exhibit 4 is 2017 FEMA flood information. There's an article regarding the 2010 flooding and the statements from the U.S. Army Corps of Engineers, as well as Exhibits 6 and 7, which are Corps of Engineers fact sheets pertaining to 2 dams, the Old Hickory Dam and the Percy Priest Lake Dam, because those 2 dams, for some reason, came into the discussion back on January 5. I was not representing Mr. Smith at that time. Certainly wasn't here in front of you, but he did retain me after that meeting occurred. And finally, we think is very important pertaining to Miami Avenue is Exhibit 9. Exhibit 9 contains information that certainly was not in front of you and was not reasonably in the concept of my client or his engineer that this kind of information was going to be discussed. There was discussions about what was happening on Miami Avenue. What Exhibit 9 lays out for you is of particular note are those parcels in red. Those parcels in red, and there's 16 of them, all 16 of those are located in the floodplain. Again, my client's 3 properties are not located within the floodplain. However, these 16 properties were issued building permits since the 2010 flood. So these are, by all accounts, these are new homes. And you can see the relative proximity of my client's property noted with the symbol at the top of that legend. So we think this information is pertinent, and in addition to this information, there was an item that followed my client's item on the same agenda on January 5, and this was an item referred to as the Water Tower project. It's a multi-family project on First Avenue near downtown, and this is a project that was approved. And if I may, if you had Water Tower on your agenda in advance of my client's agenda item, I think your decision would have been different on January 5. For example, just if you consider the factors that are very similar are as follows. Miami Avenue are 3 lots and 3 single-family homes, and these are small homes. The total square footage of the livable area is approximately 800 square feet. The water tower project on First Avenue is a 7-story multifamily structure containing hundreds of potential residents. Both of these projects involve cantilevering out over the flood zone. Both of them are elevated, the cantilevering area are elevated well above the flood zone boundary. Both involve buffer yard encroachments, and both of them are accessed by a single road. Those are simply 4 factors, and again, we're asking you here today to allow us to brief you more fully in a public hearing. We're asking you to reset this for a public hearing so that we can present this kind of information in greater detail to you if you would allow us. Despite the action to approve water tower, just prior to that decision, my client's case was denied. And there were several reasons, in fact 3 reasons enumerated by one of the members on this board for approving my client's request. And I think those items, those bases remain valid. And if I may, 3 of the factors involved the fact that there's no way to develop this property without this variance. Again, if you were to compare the water tower project, 7-story condominium tower, they may have been able to build something smaller. I really have no idea. We don't know those facts, but we'd like the opportunity to present those facts in detail to you. Secondly, this property is consistent with the FEMA regulations. And finally, there was not much difference in how other properties similarly situated had received variances to encroach in the buffer yard by this committee. So I think all of these factors are reasons why this committee deserves, frankly, this committee deserves, you all deserve to make well-educated, well-thoughtful, thoroughly vetted decisions, and frankly, we think that your decision on January 5 was not based on complete information. Finally, the water tower project proposed to provide some form of mitigation, and my client had proposed to provide similar mitigation in the form of landscaping, bioretention around the sides to comply with new LID requirements. That's exactly what Water Tower had proposed. One additional factor, one of mitigation that they had offered was to do a green roof on their multifamily tower. That's not something that's practical in the single-family setting, nor would it look good, nor would it look appropriate to have that kind of a roof on Miami Avenue, given the character and the context of the other homes there. But nonetheless, my client had offered with staff to do mitigation measures. We still propose to do that. We'll still do that, and I think that's important. So the real net effect here is if we're unable to present to you more thorough evidence, more thorough information for your due deliberation, the net effect here is that my client's property has been condemned. And this government, through 2 administrations now, has taken very deliberate efforts not to condemn property. In fact, we all readily recognize our trouble traveling throughout Nashville, and you would think that maybe condemnation here and there to widen a road or to improve an intersection is something that we could all get behind, but even that's not happening. So what I submit to you is without your consideration and without your due deliberation on the facts here, if my client is unable to build 3 single-family homes on these 3 lots, we have in effect an inverse condemnation situation, and Metro would rather prefer to avoid those situations. And so that's our presentation here this morning. We wanted to make it short and quick. Mr. Walter Davidson can readily answer your questions regarding any of the data and any of the submissions that we've made here today. Thank you, Mr. Chairman.
Was there anyone from the audience that wanted to speak either for or against this particular request?
So in essence, the new evidence is Exhibit 9. and the comparison to previous, to the water tower case. Is that what I'm seeing as the new evidence?
In the exhibits that Mr. Davidson has supplied, that directly goes to the prior statements made on January 5, points of clarification.
Okay.
More evidence than that. The new evidence, as far as I can see, is they've actually got evidence of exact what stages it was. We didn't have that. We had
Okay.
some guesses. So that's new evidence that wasn't there.
Okay.
I don't think we could reasonably expect him to bring that because we've never required that of any other applicants. So I think that's new evidence.
Okay.
The next evidence that's new is the stuff on whether or not the dam was used for flood control. They attached some articles to talk about some of the discussions that were being made. So I think that's new evidence we would not have expected them to reasonably bring before us because we've never asked that before. And then 9, I think that's new evidence because I've never heard that discussion in 4 years about emergency vehicle access and whether or not, it's a concern we're supposed to look at, agreed. But I've never had us ask them for evidence to show what that is. So I think all of those things are new evidence that could not reasonably have expected.
Fair enough. Fair enough. Now, before us today is just whether it's going to be a rehearing. We can get into some of the details as needed, but we won't get too deep. It's more just to see if there's enough evidence in front of us for a rehearing. Is the way everybody else sees it? Okay. Don, please.
Okay, I just want to do a couple of procedural things. Staff felt like that there wasn't sufficient new evidence. Do you all want to say why you thought that was the case? For the record.
Yeah, I'm Tom Halco, Metro Water Services Assistant Director for Stormwater Division. I mean, all the information was out there. The discussion about the Old Hickory Dam and whether or not Old Hickory Dam is a flood control structure or not, or whether it is a river run project, that information is well established. And if you talk to the Corps of Engineers, they classify Old Hickory Dam as a river run project, which means everything that runs into the upper end of the lake flows through the lake and through the spillway. Now, was there some storage during the May 2010 flood by the way that they raised their gates? Yes. They were able to grasp some storage out of that facility during May 2010 in that severe event. But again, everything still flooded downstream. If they had lost control of that dam and had to open the gates wide open, the flooding downtown would have been 4 feet deeper in their estimation. So that's information that's been out there, always been out there. Again, we didn't really consider that to be new evidence. The other issue with the water tower project, they're trying to make a comparison there. The water tower is on a bluff downtown. During a 100-year flood, water will not flow around both sides of the building and cut that building off. It's just on one side. So again, we just, in looking at the evidence, didn't think that there was anything that was not available to them at the last meeting.
My second procedural question is, and this is just for a matter of integrity of the process. We've started televising these hearings because we want to make sure they're very transparent, that people understand how evidence and information comes to us, and make sure we handle the process in a way that's appropriate. Have any of you all had any conversations with any board member prior to today's meeting about this rehearing? Okay. Okay.
No, sir.
All right, great. That's pretty important. All right, so, and then lastly, as one board member, casting one vote, I'm speaking for myself. I'm not speaking for the entire board. I think it is fair to say we have an enormous amount of what you might call qualitative latitude to make these decisions. And these are always, to some extent, imperfect situations. And based upon what you presented and based upon what I remember being the prevailing votes reasons for denying your original request. I don't see how the new information changes those initial decisions. And so on the point of the water tower example specifically, I remember us having a conversation about that site being much more accessible to emergency personnel than this particular site. And I remember that being a differentiating factor that we considered. And I also remember a differentiating factor between those two cases of no new development on the riverside has been approved, nor is desired at this particular site. There already is development, and there already is new development taking place in the downtown sites. And so the two situations seem markedly different. They don't seem comparable. And the only reason I say that is that we work really hard to try to respect property rights and investment opportunity. And then we try to weigh that against public interest and public welfare and public cost to the taxpayer. And it appears that what we're trying to do here in this particular area of riverfront property is consistent. And it also appears that what we've been trying to do across the street, and by we I'm saying Metro, with building permits and with stormwater variances, across the street we're being consistent. And it appears that we're being fairly consistent and judicious in the downtown site where we granted the water tower variance. I think I may actually voted against the water tower variance myself, but actually not for the reasons that I voted against this one. So I was just more concerned about, I guess, a variety of other factors that are not relevant to this case. But so that's kind of my statement of one board member's perception of why I voted the way I did and why I think it was a prevailing vote. So would you like to respond to any of those points?
Absolutely, Commissioner. We simply would like the opportunity to present to this board those comparative facts. And with a new hearing, we would absolutely do that. There probably are some distinguishing factors here. But by and large, the decision of this board to grant a variance or for an encroachment into the buffer yard in one case, further downstream as opposed to this location for 3 single-family homes, we think that those factors need to be fully vetted by this board. I fully appreciate the board's concern for establishing a precedent. Every board that I appear in front of seems to be overly concerned without establishing a precedent. That's not something I ever really present to a board or a commission because I think every piece of property is distinguishable. But given what we've seen in the minutes of the meeting from January 5, we don't see those distinctions. And so we would like the opportunity to take a look at the water tower proposal and to come back to this board and have a fully aired out hearing so that you all can weigh that. Unfortunately, my client did not have that opportunity to have those factors weighed before his case was dismissed, essentially. So that's my only point about the water tower. Mr. Palco references the dam and the information submitted now in support of what the dam is or what the dam isn't. The point is this property is not in a floodplain. We're talking about a buffer yard encroachment. We're not talking about life, limb, or sacrifice. So the elevated concern for these 3 lots, in my opinion, is not deserving based on the facts that was in front of you on January 5. We'd like the opportunity to reappear and to present of everything we have and everything the staff has, and come at that deliberately and forthright. There's nothing to hide here, but we think this committee deserves to have all the information in front of it. And if in the end, after that full hearing of all that information, this committee decides that the encroachment is not warranted, then we'll have to live with that and deal with that. But we think this committee deserves to have everything in front of it, and on January 5, you did not.
And I'll just say two more things, if that's okay, Mr. Chairman. One, are you aware your client had two hearings in front of us?
I'm aware it was on the agenda in December, but I don't have the minutes from that meeting.
Okay. And you're probably aware that we record our meetings, and those recordings reflect a lot of detail our written minutes probably don't reflect.
I'm not sure what decision was made in December. My understanding is it was deferred.
Well, I guess the point I'm making is that when you use the word that it was dismissed, I just don't want the public to feel like we didn't hear this twice. We didn't thoroughly document our conversations.
When I use the word dismiss, I'm referring to the motion that was made. There was not a definitive motion to approve or deny this case. This case failed on a motion to approve, and that was it.
Okay. I understand
Our
that.
position is there should have been another motion on January 5 to disapprove it and to vote that in according with the sentiment of the committee. That didn't happen. That's a legal technicality, which again, I think this committee should cure by having another hearing.
Okay.
And I just wanted to I believe, Mr. Gill, when you came in with your flash drive, I gave you the December recording and the meeting minutes decision letters, I believe.
Is on
You can
flash
check.
drive.
Okay. I just want to make sure the public understood that
The first
we
meeting was
heard
pretty
it.
much just a deferral. It
Yeah.
wasn't.
Well, and I guess the only
It
reason
was
I
to look
mention
at other
this,
options. You said for someone, there's a property swap with Metro, but then we came back and you said that Metro had no options.
most people only get one hearing with us when we make a decision, so that's just the only point I was making. I just want to make sure people didn't have the impression that we rushed this. We did have two scheduled discussions about it.
If it's possible to respond to the, I'm sorry, I forget all these rules now. Respond to the inverse regulatory taking issue.
Yes, I'm glad to respond to that. I do disagree with that concern. I disagree that concern should be an issue for consideration of this committee. I think that is kind of beyond the scope of what you are tasked with undertaking to determine. I think you should look at this in terms of, well, today we're only here on the request for rehearing. In January, you were making your decision based on whether or not to grant a variance using the factors that you apply in all of the variance cases that become before you. And I do not believe that you need to take into consideration the inverse condemnation argument. That is something more for my department to worry about, and your decision-making should be untainted by that. I would also respond to the argument about any concern about the lack of appealability or finality of your decision on January 5th. I believe that this committee acts by a vote of a majority of a quorum, and you did that on January 5th. It was a no vote on a motion to approve as opposed to a yes vote on a motion to disapprove. But we would certainly not take the position that wasn't appealable were they to file a petition for writ of cert in order to challenge that decision. I think to say that you had to take the second vote to fix that is putting form over substance. It's inefficient, and it's immaterial because you did make a final decision. They were denied their variance, and it's clear in a lack of a variance situation because the property is situated within the buffer that they would have to comply with the buffer requirements. And if they can develop it with compliance with the buffer requirements, then they wouldn't need to come before you. So I think they had their decision, and they could have appealed that decision as was. So those are the only two legal points that I see.
Thank you.
I respond to the water tower information. I don't actually think that's new information. I mean, it's a second argument, it's an after-the-fact argument. And in fact, I don't think that the facts of that case are any different than all the cases we hear. Also, from my recollection, we did determine that that property does get cut off because both sides of that main street get blocked off, because we were talking about that as a distinction, and then we realized, wait a minute, it's not a distinction, because 2nd Avenue, or whatever that road is, actually gets blocked off on both sides. That decision that we're talking about here was the first one I've ever heard the emergency concerns brought up. And then, like I said a minute ago, it's a valid concern, but I've never heard them brought up and used specifically to deny a project the way this project was denied. So I do not believe it's reasonable to have expected them to bring evidence. I agree with Mr. Palco that this evidence was available, without a doubt, but it wasn't something we would have ever expected them to bring in. I think that's the distinction here. And to me, what we're deciding on today is whether or not they should have another opportunity to present this case in a rehearing.
Thank you.
Mr. Chair.
Yes, sir.
I think some of the shift in emphasis in this discussion is a little bit different than my perception of the emphasis of our previous decision, and that was to focus on, and I remember specifically asking the question, is it rare that we grant variances for the Zone 1 buffer? And everyone agreed it was rare. And I remember that being the primary driver. I remember the emergency access being the secondary driver, or a tertiary driver. A third driver, tertiary driver to me, would be the consistent application of metro policy on that side of the river on this site, as opposed to the opposite side of the street. And so, and I think I'm repeating what I said earlier, that it seems like we and other parts of metro government are acting consistently downtown, and we're acting consistently here. And I don't think the emergency access was a primary driver. I think the Zone 1 buffer was the primary driver. And I don't think having another hearing about emergency access on the downtown site versus this site is going to sway our decision about the Zone 1 buffer, nor about the consistency of metro policy being applied in this particular site, which in many respects is consistent with land use law and zoning. It's not a spot zoning behavior. It's a fairly consistent application of a policy in a specific geographic zone of the river where we want to minimize development as much as possible, particularly in a Zone 1 buffer. And I just don't see anything new changing our decision in that regard. At least none of which has been presented today, I think, would change that decision, or at least my individual vote.
I don't see a lot of new information. I do see clarifications in information, and I see things presented a little clear from Walter Davidson's information he provided. So I'm struggling. It's not completely new in my opinion, but it is clarified and presented in some newer concise ways. And going, I don't want to compare cases too much, but going way back, I have used of life, health, and safety on previous variances before too. So that is always a concern of mine, because I don't want to put our first responders in harm's way trying to get to something that doesn't need to be there. So in some ways, I see there is a little bit of new information submitted to us, but I'm not completely sure it sways my vote at this point, but there's some new information. So I guess at this time, is anybody comfortable making a motion on either way?
I move we deny the request for a rehearing on the basis that the new information presented doesn't substantially change our understanding of why we denied the request to approve originally. I think I'm stating that accurately. And just one other clarifying point. I also remember specifically saying in response to, I think, one of Roy's comments that there are already a lot of houses there. And one of my concerns was that we were adding 3 more houses to the burden of first responder responsibilities. And so the goal was to try to minimize what's already happened on the opposite side of the street and not increase more burdens on the river side of the street. And just to be consistent. So for that reason, for those reasons, I think we should deny the request for rehearing.
I'd like to just comment on I understand legal's position as to why we shouldn't consider the legality of what we're doing here. I have a hard time, maybe because I'm a lawyer, to dismiss what I consider to be someone's constitutional rights when I'm making a decision. And so I can't do that. And it seems to me very clear that applying this Zone 1 buffer in this manner takes away the property owner's ability to use this property reasonably as would have been expected when he purchased this property, which is a taking in my personal view, not Metro Legal, understand that.
Just let me clarify, when they purchased the property, the buffers were in place.
That's right, but we often grant variances in these situations. In fact, we almost always do. Every time I've been a part of it, we have granted variances. Evidence of that would have been reasonable would have been the fact that the property was trading at a value which showed a developable value. Now it's not, but at the time they purchased it, it was.
Gotcha.
So that's evidence they would have had a reasonable expectation to be able to develop this property.
Yeah, they bought it knowing the buffers were there, but you're saying there's a reasonable.
That's right.
Okay, I'll follow you.
I would just respond that the reason we do not consider this to be an inverse condemnation or a taking is because what you all do is an exercise of regulatory authority. You are acting in using the metropolitan government's police power to protect the public health, safety, and welfare. That is distinct and distinguishable from a taking of property interests that Metro might conduct in the context of a condemnation of property. And we do not think that the two are the same.
Yeah, and I understand that distinction that you're making, what we're doing as a board versus what the regulation as it was passed. I also feel that this is an arbitrary and capricious decision based on, because I do not believe that we apply the same standard to everything. I understand that we're looking at this property and we're saying it's on the riverside, therefore we want to leave it there because everybody in the neighborhood thinks it's pretty if it's not developed. I think that's a great policy decision that should be made at council or someone who wants to pay the people for that property. Not something at this level where we're just applying. The property obviously has a hardship. It's unquestionable it has a hardship. Based on everything I've seen in this committee, we would typically provide a variance for this. And so that's why I think we should give them a rehearing.
Thank you. Thank you, Slade.
Mr. Chairman,
Yes, sir.
do you mind if I add another comment? Just to repeat what I stated last time, I know Mr. Slade will remember in the first hearing, our first effort was to try to find a way to have the property purchased because that was the consistent Metro practice of policy on that side of the street. I think we heard a letter from a lady who had an investment interest in property, and then Metro came in and bought it at a different price. You remember, I think Ms. Key read that letter earlier. I think Metro's behaving consistently in this situation. I do think what's unfortunate is for conditions not to be more opportunistic for Metro to buy the property. Obviously, having a structure on the property made it more attractive for Metro to buy it, right? Because they're removing a risk. Not having a structure on the property makes Metro a little less interested in buying it. I will say, however, that I studied land use law in graduate school, and I studied takings Supreme Court cases, and I distinctly remember a takings being a complete removal of all economic opportunity for a piece of property. And there are other economic options for this property. Selling it to a conservation land trust, selling it to a Park and Greenways nonprofit, selling it for environmental purposes. There are economic outlets, so all of the economic outlets are not completely unavailable to the applicant. They're not ideal, but there are still some economic opportunities.
That's why we had the deferral in the first meeting.
Yes, yeah, and
We discovered there weren't any.
well, there were no Metro options. That was what was stated for the record, was that Metro did not see any options, but that doesn't preclude any other party from approaching you and preserving it. So
Except for people that want a house there.
I agree, and it's very unfortunate that we don't have a ready remedy for you, and that's why I work so hard to try to do that right off the bat, because I could see where this was going. But with that, I just want to say that for the record. So.
Thank you, Mr. Galbraith. Anyone else on the committee want to speak?
You do have a motion on the table. There's been no second yet.
There has been some.
No, it hasn't been seconded.
I'll step forward and second it just to get it to a vote, so we can keep this moving forward. Sorry.
Oh, I'm sorry. I thought you were more discussion.
No,
All right, there's been a motion and a second. Any further discussion?
please read the motion before we vote on it.
Okay. Mr. Dodd Galbraith made a motion to deny, stating that the new info doesn't substantially change why they denied the request originally. And then I have noted to not increase more burden on the riverside and to be consistent in some form. Is that
Okay, so the motion is to deny the rehearing.
to deny the rehearing, the request for rehearing? Mr. Galbraith, did you want to re-clarify my second statement there? I had that it doesn't substantially change why they denied the request originally, but was there anything additional? I may have probably misstated that.
Next time I won't talk so much when I make a motion. So I'll just say this. I don't think, and I may have to consult counsel on this, but we're voting on whether or not they presented indications of new evidence that should be represented at a new hearing. And so my motion is to deny based on the fact that I don't think they've made a strong enough case with their list of possible evidence to require a rehearing.
The exact language is new evidence which could not reasonably be presented at the previous hearing. You're making a factual determination as to whether they have presented such new evidence that could not reasonably have been.
Yeah, and that's the basis for my motion, so, even though I didn't articulate it well to start with. So. Do you accept that clarification on your second? Okay, thank you.
Yes, sir.
All right, there's been a motion and a second. All those in favor of the motion to deny the request for rehearing signify by saying aye.
Aye.
those opposed signify by saying nay.
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 Okay, that motion does not carry.
Mr. Chairman, I would encourage there to be an affirmative motion in this case. Thank you.
Motion to grant the request for rehearing. Based on the fact that Motion to grant the request for a new hearing based on the fact that new evidence has been presented that could not have reasonably been presented because those issues aren't typically discussed at this meeting.
Okay, there's been a motion and a second. All those in favor of that motion to approve the request for rehearing signify by saying aye.
Aye.
Okay, that is a total of 4. All those opposed say nay.
I'll be consistent and say nay.
The vote is 4-1. The ayes have it, and the motion carries.
Thank you.
We
We'll
would,
see you next month.
okay, I was going to say, we would like to address the rehearing would be held next month.
Next
Is that
month.
confirmed?
That's
Okay.
our understanding.
All right, okay.
All right. Thank you, guys. And
We do have a business item on the agenda. If those representatives would like to come to the table, we'll go ahead and get started with that in just a few moments. We will go ahead and move to the business portion of the meeting, and if you will look in the packets, each of the members, you'll see the bottom packet that has some 11 by 17 sheets, and then also clipped to that, there's some 8.5 by 11 sheets. And this is related to the Mill Creek Soccer Complex, which is now, I believe it's now called Orchard Bend Soccer Park. And the Mill Creek Soccer Complex was granted a variance. It was number 2016-00023 with conditions, and that was on September the 1st of 2016. And there were multiple variance requests, and within that packet, the last 2 pages, you'll see the previous decision letter. Those variance requests involved disturbance and encroachment of the floodway and floodway buffer. I'll just go ahead and read that so that it'll give you some history here. The original variance request was to allow the following: disturbance and encroachment of the floodway and 75-foot floodway buffer, 50-foot Zone 1 and 25-foot Zone 2 of Mill Creek for construction of multiple athletic soccer fields with associated grading and installation of EPSC measures as shown on the plan of record. There was excavation cut volume of 11,361 cubic yards below the 2-year elevation, which is 523.34, to allow that to be included in the compensating storage capacity calculations. 3 was placement of stormwater BMPs in the buffer. 4 was placement of modified buffer signage. And 5 was continuous mowing and maintenance of a significant portion of the buffer. The grading permit application, it's SWGR-T 2016-03-9648. It's currently under technical review, and at this time, changes to the project require that the committee address those issues related to the variance plan of record and the revised plan. The appellant is here today to request a special hearing. I will read that from the Appendix F, that description of a special hearing. Special meetings. The committee, the chairman, may in emergency situations call special meetings at a time and place of his choosing. Whenever such a special meeting is called, the public shall be notified in the same manner as provided for by Section F1.1.3, and that relates to the same public notice that we do with any case that's brought before the committee. And at this time, I will just turn it over to the applicant, and they can explain their reason for the request for rehearing, and we'll, if needed, we'll let you look over the plans before we start that if you think you want to, or you want to go ahead and proceed with hearing from the appellant.
I'm comfortable going ahead and hearing from the appellant because this is just a request for rehearing, so we're voting to whether to rehear it or not, and to set up a special meeting, right, to rehear instead of a special meeting.
Okay. All right, Ms. Ratz, if you'd like to go ahead and get started, and if you could just introduce everyone at the table.
Sure. My name is Rebecca Rotz. I am with the Metro Parks Department in the Planning and Facilities Division, overseeing this project from the park side. And I have today...
My name is Stephen Carras. I work with Collier Engineering design firm taking care of the project.
I guess we're here today to request the special meeting. Back in September, we had already applied for our stormwater grading permit, but it wasn't complete, and you heard our case then. Throughout the review process and going into technical review, we've had to make revisions on the plan, and you should have an outline of those revisions. They include additional BMP measures, which also now have moved into the floodway and the buffer. But those BMPs also are replacing some asphalt that we had on the original plan, so we've decreased the impervious surface. The earthwork calculations have changed. We'll be removing more.
Cut. Yeah.
Go ahead.
Yeah. Well, since the approval of the variance, we met with Metro Water Services, and they required us to provide detention and bioretention to treat the water going off the lower parking lot. So we took care of that. We resubmitted in November, and then we got comments back this February, last month. And we already completed responding, taking care of all these comments. And we're still working with the Metro Water Services through all their concerns for putting these facilities in the floodplain. So it's still under review by Metro Water Services.
And there, I guess, in lies the problem. We would have much preferred to have been back here sooner, and we're at the point now where we are pushing up against the back end of our window to sprig these fields. So there's 7 fields that really need to be sprigged in mid-June in order to get enough time for the grass needed for these fields to grow in before the winter. In order to get sprigging in mid-June, we have to get irrigation in place because you basically have to make it a swamp for sprigging, and the fine grading has to be done as well. So we really need to start yesterday, of course, as everyone does. So we would just like the chance to have, instead of waiting until the April meeting to potentially get you all to hear this at least 2 weeks ahead of time, give proper notice if we need to, so that we can move forward. The timeline works, so that we would have to wait until June 2018 if we can't start this year. And I think one thing that we'd like to put out there is, we're talking about taxpayer dollars for this project. So I hope that, maybe means that it won't be a precedent-setting issue, that it's a metro project that everyone will be benefiting from. So that's where we are today. I don't know the technicalities of the rehearing with changes to a plan. We'd like to be able to potentially even work with staff through some of these issues, but if that's not possible, we'd like this special hearing.
Okay, thank you. And I do appreciate this is a metro project going through the most proper channels of coming back through this. So I do appreciate you guys coming back to get this clarified. Not sure what we need to do if it's under my jurisdiction to allow the special meeting, it seems like. I guess I'm looking for around at the group. I'm in favor of granting a special meeting. We can start looking at scheduling that, in my opinion. Is there any opposition to a special meeting?
No.
Okay. Seeing none, I'm very open to this special meeting, and I see the need to get it done fast to help you guys out. Paula, what is is 2 weeks out the minimum that it would take for us to notify public? And
At least 2 weeks.
Okay.
We would, unless they have, are you all, is this your submittal for the meeting, or would you have some additional materials?
It should be our submittal for the meeting unless
Yeah, it
we
should
get minor comments from technical review. We're confident we're almost there at technical
Okay,
review.
so we're talking about within today or tomorrow, an agenda going out with the public notice signage.
Gotcha. And that would put the special meeting on I'm just going to say the 16th. I'm on the right
Is that
one?
what, that Thursday?
Yeah. Today's the 2nd, the 9th, the 16th.
I actually have a meeting that morning.
I'm out of town all week.
I'm fine. Friday after, I'm all right. So that's 2 of us, 3 of us.
Friday
What do
after.
you like that Friday after? 17th?
And there's a chance I might be out of town, but I haven't got anything scheduled yet, so I'm flexible still on that 17th.
We got Roy and Deborah too, so there's 2 more people that would be options. We know at least 2 of us will be available. Ann, do you know if you're good?
I can do the 17th.
Okay.
Is that a Friday?
That's a Friday.
Okay, I will have to check on location. That I'm not sure about, but if you all are available, we'll make that happen.
Okay. So I would say, yes, let's try for the Friday the 17th.
Everybody has to wear green.
Everybody has to wear green. That's another condition. It's the time and place to be worked out with staff and with, I'm not sure if this room's available, but we'll work on that.
Great. Thank you so much.
Thanks.
Do we need to have a motion on this, or just?
The chairman is allowed to
Okay.
make the decisions.
All right, so we've got it done. Okay. All right. That was the only item in the business session. Was there anything else that you all needed us to present in a future meeting? The next meeting will likely be pretty full, so we will not be able to bring a discussion about blanket variances and that, not at the next month's meeting. So we'll have to delay that again.
Do we know how many applications we're going to have? Obviously, the
We've got
discussion we
those
just got out of.
3. I think there were about 7. So
7 other ones?
these 3, I'm including
Including?
some, 7 total. Yeah.
I guess I've got one comment before we adjourn, which appears to be imminent. In order to give our rehearing applicant that is coming back next month that we just heard prior to this last case, a properly, thoroughly, technically vetted experience, I'd like to ask staff to work really, really closely with that applicant to make sure all the evidence that needs to be presented is presented, all reasonable materials that need to be presented is presented, so that the applicant gets as fair a hearing as possible, and so that it doesn't get into a technicality that causes it to have to come back through another cycle of review. So, and I'm not saying that was anybody's fault. I'm just saying this is a good opportunity to make sure we resolve it the third time around. So, and because it's expensive for the applicant to keep having to hire consultants and attorneys to come back and redo this, and I'd like to give him a fair thorough hearing.
Okay, thank you, Dodd.
Okay. All right, is there a motion to adjourn?
I move we adjourn.
Is there a second? Second. All those in favor say aye.
Aye.
It's unanimous, the motion carries. We'll see you on the 17th.
Thank you, guys. Appreciate it.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.